litigation lawyer just starting out in the profession, this is one way that the client sitting in front of you definitely knows that you are new and amateur to the profession. You say, Section so and so Act says that so and so can happen. And the client has narrated their entire story to you. What experts, what experienced advocates tell the client is that we don't need to go into the nitty-gritties of the sections. This is the kind of petition that we will file. This is what the opponent will say. This is the amount of time in which the opponent will come and give their replies. This is the amount of time it will take us for interim relief. This is the time it will take us for final relief. X, Y, Z are the possible impediments that may come up to because of which you have, say, a 50%, 80%, 20% chance of success. And that's how you're able to convey to the client that you're someone who understands this in and out. Now, obviously, do you fake it till you make it? At the very least, don't just look at the court judgments, but also look at the prior orders being passed by the court in those judgments, because case status prior orders are all uploaded on the internet. So when you have a judgment that you are reading which sets down the law, also look at how many dates did it take for that judgment to come. What usually happens when a matter is filed, say for example, client says bail. Okay, it's not like we go to the court and we get bail. In how much time will the bail application be ready? When will I file it before the registry? In how much time will it take to get it cleared from the registry to get it listed before the honorable court? On the first date itself, will the court grant interim protection or not? What will be the next date given? What could be the possible impediments? What could the police come and say? What could the judge say? What will be our response to that? And approximately in how much time will final bail be granted? These are things you should be telling the client instead of Section 438 CRPC says anticipatory bail should be granted. And in judgment of so-and-so versus so-and-so, anticipatory bail was granted to a person accused of a similar offense. That is what you need to say to the judge when you're arguing things before the judge. But the client needs to have a far more holistic, better view of the situation. And if you do it this way, there is a much better chance that the client will want to sign up with you.